Thank you very much. I'll now call Alexis Siemon, a PhD candidate in the Princeton University Department of History. Her research deals with the Qing Dynasty law and local local government. She is currently writing her dissertation on judicial authority in 18th century China, drawing on her archival research in Beijing and Taipei over the previous year. And
Thank you. So, since 15 minutes is nowhere near enough to even summarize the state of Qing law or the colonization of Taiwan, I'm going to try something a little bit different. I'm going to jump into describing a particularly interesting and unusual case, and then I'm going to try to discuss some of the broader legal ramifications of the case and why it and what makes it stand out. And hopefully, in doing so, I can convey enough of the background and importance of the Taiwanese colonization effort that something will get across other than just the interesting human drama of this case. So this case began in 1725 when Magistrate Tan Jingzheng investigated the murder of Mu Guo, a woman from the local Aboriginal Babuza people. Magistrate Tan was the first ever magistrate of the newly created Zhanghua County on the island of Taiwan. Mu Guo's husband came to the magistrate accusing a Chinese man, a Mr. Law, from the neighboring village of Chinese people near the Babuza tribe, of murdering his wife. The Chinese man confessed, saying that a few years earlier, he and Mu Guo had carried on an extramarital affair that had eventually been broken off by Mu Guo's decision. So, several years later, the year of the case, Mr. Law had tried to rekindle the affair and had been spurned. When he saw Mu Guo traveling publicly in a wagon with a Babuza man who was not her husband, he became convinced that she was instead carrying on an affair with this other man, and this is why she had spurned him. So, he said in his confession, filled with a jealous rage, he followed her to her house, confronted her, and stabbed her to death. Now, with this confession, the murder case itself was fairly simple for Magistrate Tan to solve. Confession was what you needed to solve a criminal case in the Qing. However, he still had a couple of loose ends to wrap up. In a Qing case, not only did you have to solve the central crime, you also had to solve any adjacent crimes. So in this case, Magistrate Tan had to determine whether this third man who was in the wagon had actually committed adultery with the now deceased Mu Guo. So now Magistrate Tan concluded in his report to his superiors that were these people Chinese, their public behavior carrying on in public together, traveling in a wagon together, would be clear evidence of adultery. However, the uncivilized Babuza people have different customs. Their men and women are free to appear together, married or unmarried, and so this was no evidence of adultery. Since the man did not confess to adultery and there was no other evidence for adultery, he concluded that this Babuza man was to be found innocent and not punished at all. This was a fairly big deal given that the punishment for adultery included 90 blows of a heavy bamboo cane. So what makes this case unusual? Well, there's three things that make this case particularly noteworthy in the context of Qing law and in particular the law of Taiwan. The first is that Chinese magistrates did not have the authority to make the decision that Magistrate Tan made. The laws of evidence, the laws of sentencing in the Qing were highly circumscribed for a magistrate who is pretty much the lowest level of territorial official part of the ranked bureaucracy. So it's very unusual that he was able to interpret based on this custom. Qing magistrates did not have the right to set precedent. They did not have the right to interpret based on other precedents unless these had been enshrined and approved by the emperor. They did not even, at this point in time, they did not even necessarily have the right to use analogy in their sentencing. So to draw on the customs of another people to determine whether evidence was worthy of inclusion was highly unorthodox and unusual. And so it's that his decision was approved by the higher courts, all the way up to the emperor, in fact, is definitely noteworthy. The second thing is that this exercise of independent discretion stands out in contrast to the legal and administrative trends of the Qing dynasty at the time. The Qing dynasty is known for being one of the more highly centralized and controlled dynasties in Chinese history. And this is during the period under the reign of the Yongzheng Emperor, where a lot of the administrative and legal changes that we point to when we discuss how centralized the Qing dynasty has become, this is when they're happening. We don't have time to go into all of them, but the emperor is taking steps to be more directly informed about what's going on in these far-flung provinces and have a direct personal say in anything that's going on. And a third thing is that this was also the time when the Qing dynasty was starting to more heavily regulate sexual morality. It was increasing the penalties for things like adultery, and it was venerating chaste widows. It was increasing the standard of proof for rape so that a woman had to prove that she had strenuously resisted. They were, in the next year or two, they were going to formally make homosexual sodomy illegal. So again, this permissiveness definitely stands out as unusual, even to a non-Han person. So why then did this unusual case come to be, and why was it approved by the prefect of Taiwan, the governor and governor general of Fujian province, which Taiwan was a part of, the local judicial commissioner for the province, and then finally the board of punishments and the emperor himself? Any capital case had to be officially approved by the emperor. So now this is actually ironically because of some of the trends that I just outlined. So Taiwan occupies a unique position in Qing colonial history. For one thing, it's the one frontier or borderland that's not only coastal, it's an island. Now, the Qing, which was ruled by the Manchu people, was not a particularly maritime-focused dynasty, and Taiwan was one of their last territories that they managed to take back from the Ming dynasty, and consolidate power. So they always felt a little bit uneasy with Taiwan as a coastal island, which in fact increased the degree of centralization and direct control that they wanted over this. Now, what this meant was that, for one thing, they did not adopt the previous model that they'd used on other southern frontier border regions with heavy minority populations, such as Yunnan and Guizhou. Instead of using that model where they had local chieftains directly control their own indigenous people, with Chinese officials just running interference, until eventually these Aboriginal people were ideally Sinified, adopting enough of the Chinese cultural norms that they could just be administered by a Chinese magistrate. Failing that, the Qing would also just wait until enough Chinese migrants had arrived to the area that the Aboriginal people were outnumbered, and again, you could just place a Chinese magistrate there and administer Chinese law. Now, in Taiwan, the Qing skipped this. They were already trying to phase out this local chieftain system, the tusi system. And so instead, they simply placed magistrates directly in Taiwan and expected them to adjudicate any disputes, not only disputes between the Chinese and Aboriginal populations, but also disputes inside Aboriginal tribes, all of this according to Chinese law. They also, because it's a coastal province or coastal prefecture, they insisted that these magistrates come from the same prefecture. So any magistrate on Taiwan had previous experience being a magistrate in nearby Fujian province just across the strait. Now, since magistrates in China were never ever assigned anywhere in the province that they were originally from, and the language or dialect differences in China were pretty drastic, most magistrates who arrive in their new county that they're administering to, they don't speak the local language. They don't know the local elites. They're very disconnected, and it can take several years to really start to get a feel for what they should be doing in their counties. However, these magistrates arrive already having some familiarity with Fujianese culture and the Fujianese Min language. And so they're unusually knowledgeable about local conditions. Even if they don't have previous Taiwanese experience, they at least have related experience to draw on. So instead of these local chieftains and paired with inexperienced magistrates, you simply have magistrates with a degree of local knowledge that is in fact greater often than their superior officials, and they are directly responsible for the welfare and both cultural welfare according to Confucian norms, and also the actual food and water and shelter welfare of not only the Chinese people in their area, but also the Aboriginals. And so, as a result, their jobs and possibly their lives, should there be a violent uprising, are directly impacted by their reception and their ability to relate well to these Aboriginal tribes. So, not only that, because Taiwan at this point in time is a brand new Qing territory, and like I said, this was a brand new created county. The Magistrate Tan can claim to his superior officers, to superior officials, a degree of knowledge about the Babuza tribe and the other local tribes that no other official can. And so, for Chinese magistrates who often had a lower level degree than their superiors, who often had less administrative experience than their superiors, they had scored not quite as well on the civil service exam as their superiors. This is very unusual for them to be in a position where they can make this sort of strong, definitive claim to local knowledge. And that is exactly what Tan was doing when he explained that no, it's actually based on these customs, these different customs and these different cultural norms. That's why I'm able to not further investigate this case. So the result of all of this is that even though Magistrate Tan was applying Chinese laws, the Qing laws about adultery and about extramarital relations, and not just sexual but also public, to these people, he's also able to grant them a degree of cultural leeway that wasn't necessarily extended to other minority groups who were directly under the control of magistrates. I've seen cases in southwestern China where Muslim groups and Miao groups in similar cases have tried to articulate their ethnic differences as a reason for committing the crime, as in a plea for extenuating circumstances. And these tend to be less successful than it was here. And now part of that is that the magistrate has this extra knowledge, but he has this strong incentive to accommodate them. Taiwan had recently experienced a rebellion that had briefly driven the entire Qing government off the island. So being able to maintain stability and being able to claim a degree of local knowledge that allowed him to argue that he could better maintain stability is, while unusual for a magistrate, is an example where this magistrate is able to not only has reasons to accommodate this Aboriginal people, he also has strong political and administrative justification for doing so, and he's able to do so in the belief that he will find administrative support from his superiors, which in fact he does. He has a fairly successful career until retiring upon the death of his mother to go into the official Confucian mourning. So to sum up, we consider the Qing to be this highly centralized and very top-down, both administrative and legal regime. And in general, I tend to agree with this characterization. Even the areas where I, in my research, have expected to find magistrates finding places to exercise discretion, I often find that they then get scolded for it by their superior officials, and it can either impact their career or at least result in their decisions being overturned. But what we see is that in these sort of transitional moments, as the legal norms are being established, you can actually take advantage of the increased drive for centralization and to find these places where there's a lack of pre-existing structure, and you can use that to carve out officials can use that to carve out a greater degree of discretion for themselves, and local minority groups can use that to carve out some small degree of cultural accommodation, even while they're facing increased pressure to acculturate. So, thank you.
Thank you.